Thank you. I appreciate it. I appreciate it. So I'm Mark Zwillinger. I'm one of your FSTA board members. I'm also the head of Zwilgen PLLC, which is a 19-lawyer law firm that is devoted to keeping internet businesses safe online. I've had the pleasure of representing fantasy sports operators, both daily and season-long, for the last 6 years. I've been representing FanDuel in their litigation and legislative battles for the last several years, and I have the pleasure of moderating today's panel on legal, legislative, regulatory, and litigation updates. Not much to talk about, I assume, so we'll be off quick. No, we have plenty to talk about. It's been one of the most interesting years. I don't want to say exciting, except maybe in the way watching Nightmare on Elm Street is exciting. We've had a lot of twists and turns this year. I liken it to be on a roller coaster ride. We've had ups and downs. We've had twists and turns. Some were unexpected, but we're mostly staying on the track. And that's what we're going to be talking about today. What is that track? What's happened in the past 6 months? Why has it happened? And where are we going as an industry? So to do that, I put together a star-studded panel. Everyone here has been on the front lines of the fantasy sports legal industry for a while, starting with Peter Schenke. You know, he's the president of RotoWire, but he has been the lead on legislative efforts for the FSTA for many years. To his right is Jeremy Kudin. Jeremy is the head of the public policy practice at ORIC. He represents FanDuel and DraftKings and the entire FSTA on the state-by-state lobbying efforts, and we're going to hear from Jeremy about what's going on in the states. And then right here to my right, I have Doug Gansler. Doug used to be the Attorney General for the state of Maryland, and while he was the Attorney General, he was also the president of the NAG, the National Association of Attorney Generals. So he is going to be able to tell you today why the Attorney Generals are doing what they're doing, how he would think about things, and what has been happening in the different states, including in the state of Maryland, where Doug was the Attorney General. He'll explain what's going on there. So we're going to try to do two things with the panel. The first part is we're just going to try to give you some updates. What's happening and why is it happening? And we'll explain what's going on in litigation, and the legislation, and regulation. Then after that, we're going to talk about the trends we're seeing and what people can do, what the industry can do, what operators are doing to get to what Peter start with what Paul started with, which is an outcome where we have clear legislative mandates, clear legality in the majority of the 50 states. So let's start with the legislative update, and I'll turn to Jeremy. Jeremy, you've been busy. There have been a lot of states in play. Some of the bigger states where all the our members are and players are: Florida, California, Illinois, New York. Can you tell us what's going on the legislative front in those states?
Thank you, Mark. I think that, so a lot's going on, and you can read Legal Sports Report every day and see how it's going. But in all seriousness, I think that I want to make 3 points that tie into what's going on in those states. First is that, as Paul mentioned, this was not a knee-jerk response to the state legislatures. As early as last February, we started to come up with a strategy, FSTA, DraftKings, FanDuel, of a measured approach to passing legislation that would confirm that fantasy sports are legal in each of the 50 states. So we started with 2 lobbyists in 2 states last February. We now have somewhere in the range of, I think, 75 lobbyists in over 30 states. And in each of those states, we are pushing for affirmative legislation. We don't want to live in a world of ambiguity anymore. As for what we're doing in states like Florida, some of you may have seen that we had a committee hearing last week on a bill that looks very similar to other bills that are out there. They are bills that, one, exempt family or confirm that fantasy sports contests that meet certain specified criteria are exempt from those states' gambling laws. So that's just a confirmation. And then 2, they set forth I'll dare say, a regulatory framework that requires operators of a certain size who offer paid contests to comply with certain requirements, which in my view are important requirements, and they're requirements that address some of the perception concerns that are out there in the press or have been out there. Again, I would stress that this is an effort that's been going on since March of last year, February of last year, not something that we started doing in October. And the best example of that is Illinois, where Representative Zalewski introduced a bill in April, just a bill title, about regulating daily fantasy sports. We met with Representative Zalewski, educated him on our issues and on how our contests work, which is absolutely critical to what we're doing. And in November, he introduced a bill that other states have followed in their bills. So that state is also concerning. So let me step back. With Florida, we have a committee hearing. Next week, we have, I believe, another committee hearing in the House. And we're hoping to pass legislation out of Florida no later than the first week of March. As respects to Illinois, we have bills introduced there in both the House and the Senate. For those of you who live in Illinois, you know that there is a much bigger issue than fantasy sports in that state, and that's the fact that the legislature and the governor have been unable to agree upon a budget for 2015, and still now have the next year's budget. So that's going to probably take the first couple months, but in Illinois, we expect bills to be in committees and up for votes sometime in April, May, probably the first or second week of May. New York is a different situation. While we had an informational hearing that Peter and I, we may still be there, and we're just imagining the rest of our lives that have passed since. It was like a 5-hour hearing. We have been working with the committee chairs of the relevant committees on legislation. I'm hoping that we will have something in the next month or so. The state usually spends most of its first couple months working on a budget, and then we believe our issue will start moving in March or April. California, there was a hearing 2 weeks ago. Sorry to get so detailed here. There was a hearing 2 weeks ago on a bill that was introduced by Adam Gray, the chairman of the Governmental Organizations Committee in the Assembly. That bill was actually introduced in September, again, before the media coverage. Bill got out of committee 18-1 and will be up in the Appropriations Committee tomorrow, I believe. And we will have representatives there. So we are in a good position right now. I will stress that it's very, very, very difficult to pass legislation. I fear I'm dating myself here, but I'm not sure how many of you remember the Schoolhouse Rock anthem, "I'm Just a Bill." It was about a little bill that went to Capitol Hill. I'm not gonna sing it. But that was a bill about putting a stop sign in front of a railroad tracks for school buses. And if you watch the video, that bill nearly died in committee. I mean, that bill died. So like, just imagine how hard it is to pass bills. It often takes 3 years to pass legislation. I also kind of analogize it to the Hall of Fame. Very few first ballot Hall of Fame candidates. Most bills take time. It takes time to educate members and get them comfortable to address opposition. We are definitely trying to condense that time period, but I just want to set expectations that we're not going to pass bills in 50 states, in large part because at least 10 of the states aren't even in session this year. But we are going to work really hard to get at least, a half dozen, 10 bills passed this year, I hope. And then next year, more, and the third year, hopefully we'll complete that goal of getting 50-state legislation on fantasy sports.
Peter, you've been involved in this effort for a while. You've been physically going to some of these states to testify and to meet with legislators. Tell us a little about what you've been doing personally.
Yeah, I mean, just to say what Jeremy, I guess I'm not the, keep going. I've been doing this effort since 2011. We first passed a bill in Maryland in 2012, and then Kansas this last spring. So this is really a continuation of that effort that we've been trying to do the whole time. What I've been doing is I've been going to as many hearings as I can. Before most of the legislative sessions began, which in January, most states are January through April or so, there were a couple of big informational hearings. One was in New York that we talked about that lasted over 3 hours. Another one in California. And then I also went to Massachusetts where there was a hearing on the proposed Attorney General regulations. And I'm trying to make sure that the FSTA, the industry at large, not just daily, but the season operators, the information sites, that we all have a voice in this and that we're involved in making sure that these regulations that, for the most part, that we are embracing also, work for everyone in the industry, not just the big companies. And so when we were in Boston testifying, we made a lot of key points about that, how some of those proposed regulations impact information companies, season-long providers, postseason leagues, and so the FSTA. My role is to keep on top of it, but also to advocate for everyone in this room to make sure that the other companies, have a say in the process.
That's great. So every year and at every conference we talk about legislative updates, and we've been talking about the difficulties in getting bills passed. And while we've had more activity this year than years before, what's new about this year is the Attorney General activity. Attorney Generals have issued opinions. We've been hearing more about Attorney General involvement. We have Doug with us today. Doug, if you could, first give everybody an update on what the Attorney Generals have been doing, and then we'll talk about, after that, their motivations and how to change the course of the landscape.
Thank you, Mark, and thank you for having me here. A year ago, I was still the Attorney General of Maryland. Today is actually my one-year anniversary of being in the private sector, so I have a very different perspective, but it's still fresh as the Attorney General. But let me just say this, for all of you that are lucky enough not to be lawyers, I want to just take a step back first and explain why we're having this panel. And the reason why we're having this panel is because most legislation, or a lot of legislation, is handled at the federal level, and there's uniformity at the federal level. The federal government says something, and it's done, and we move on, and everybody operates within those rules. The federal government, as you know, under 4 statutes that potentially could be relevant here, have basically, that we've taken the view that they are okay with fantasy sports, and they're not going to regulate it, and they may ultimately, and we'll get to that later, but right now, they're not doing it, and the states are doing it. And so that's why we have this panoply of different regulatory structures and different things going on in the states. And within the states, and I think Jeremy and Peter have talked about it, there's 3 different things we need to worry about or look at, right? Court opinions, legislative bills and laws, and attorneys general. And right now, the activity, as recently as yesterday, has been in the attorney general sphere, and sort of what's going on there, and how do those 3 areas interact. And so, you know, it all started, and I've been playing fantasy since the 1980s, baseball, though I find baseball a little boring, but I did back then, played it, and still play it, and more in football. But you know, I think this is an interesting area that attorneys general have just started to get into, as you know. And the issue is twofold, and I think it was brought up at the beginning as they look at it. They look at 2 different things and why our attorney general is getting involved. One is the integrity of the sport. Is it fair? Does everybody have a fair shot? And they're supposed to be protecting consumers in that space. And second, is it violative of the laws of their state? And we'll talk about sort of within the individual states. But Eric Schneiderman in New York kind of started this, right? So he sent the first shot across the bow and said, you know, I'm going to declare this illegal. This was actually our one tie so far, because the same day the court said, well, not so fast, let's hold off and see what happens. And then state after state after state has looked at this, and mostly on the Attorney General side, and we have to sort of look at where we're going to go and what we're going to do. And Mark asked me to briefly touch on 2 states, Illinois and Maryland in particular. So when I was the Attorney General in 2012, Maryland became actually the only state that specifically carved out fantasy sports and said it's okay. Now they're revisiting that in the legislature this year. The Senate President asked the Attorney General, my successor, to opine on whether or not it is okay under the rules. And all these attorneys general, when they're doing their opinions, are looking at the laws of their state. So Schneiderman's was a little harder because he had the material element versus predominant. You know, there's different standards, but they're basically kind of looking at the same idea. Maryland and Illinois took the same approach, sort of. So Lisa Madigan, General Madigan in Illinois said, it's illegal, but I'm not going to do anything about it until after the legislature. In other words, punting it to the legislature, letting them make their decision, and then she'll revisit it, as will the courts after the legislative session. The idea is that all these wonderful lobbyists that you have can fix it, and people can play fantasy sports, hopefully, and probably within a regulatory scheme. Maryland, the same thing. It's a 22-page opinion, which really doesn't say anything at the end. It sort of says, well, let the legislature decide. And that's where they're going to go in Maryland as well. So there is an interplay and interaction between the attorneys general and the legislature, and ultimately will go to the courts. Most of these cases have not gone to the courts, and when I talk later, I'll sort of say why that's a good thing. Because right now, I think that right now is the time to fix all of this and address it all in one fell swoop, and everybody can continue to enjoy playing online sports.
So I'll do the litigation update, and then we'll go back to the panel for a series of questions about, you know, what we're doing and why we're doing it. But just to play off of what Doug said, you know, the Attorney General will issue an opinion in a state. It's not typically self-executing. It's just an opinion of the Attorney General of how the laws should be interpreted. It doesn't make any existing law off the books. It doesn't create a self-executing, everybody has to immediately follow that opinion. That opinion has to be tested in the courts. So I'm going to talk about 3 different states and how things played out. In New York, when Attorney General Schneiderman issued the opinion, it wasn't just an opinion. It also came with a letter to certain operators saying that this is your 5-day notice, that if you don't stop operating, the Attorney General is going to file a lawsuit to enjoin and stop their activities within the state. FanDuel and DraftKings got that letter and filed suit against the Attorney General first, filed a declaratory judgment action to declare their actions legal in the state. and asked to restrain the Attorney General from taking any further action against them. The Attorney General filed for an injunction to stop FanDuel and DraftKings from operating in New York, and it went to court. The initial decision from the lowest court judge in New York, that's the Supreme Court, but it's the lowest court in New York, judge said, I will enjoin FanDuel and DraftKings. I find their activity violates our gambling statute. FanDuel and DraftKings went to the appellate court, said, we'd like to appeal this, and we'd like a stay of the decision pending appeal. A single judge of the appellate court granted that stay, which lasted for 2 weeks, until the full appellate court could hear the appeal. The appellate court then considered a permanent stay and granted what is, in effect, a permanent stay of that decision until the case could be fully heard, until DraftKings and FanDuel could be heard on appeal, which will be at a minimum of 6 months. So New York is on hold, and it started with an Attorney General opinion and then an enforcement letter. Illinois, as Doug said, started with the Attorney General opinion, no enforcement letter. So FanDuel and DraftKings again filed suit, not to enjoin anything, but to get their activities declared legal in Illinois. That case is pending, and everything is on hold while that case is resolved. Third state, Massachusetts. No Attorney General opinion that fantasy is illegal. In fact, an effort to use the Attorney General's regulatory authority. She had the authority, Maura Healey, to issue regulations in Massachusetts. She issued draft interim regulations making fantasy clearly lawful and be able to operate in the state of Massachusetts if certain consumer protection rules are followed. And we can talk more about those if we need to, but they're generally for the protection of players, the segregation of funds, and to make sure that it's a level playing field. So we have 3 states. We have New York, full enforcement action in the courts, stayed. Illinois, opinion, litigation pending, brought by fantasy operators. Massachusetts, lawful conduct of fantasy sports with regulations. Very different approaches. So we're going to talk about why that is, and since Doug has the mic, I'll turn to Doug first and say, Doug, why would these attorneys general take these vastly different approaches to the subject of fantasy sports?
Well, just interestingly and ironically, the Attorney General of Massachusetts, Maura Healey, actually played point guard at Harvard in basketball, and she ended up playing in Europe, so she likes sports. And I think let me just say what's the same about all the attorneys general before I say what's different. The same is they all have to get elected. And they have to sort of be they have to be in the mainstream media, and they have to be seen as protecting consumers and protecting the integrity of what's going on. So they all are looking at this one by one. Once one of them does something, usually the rest start to do something. They want to be part of the act, not only because they want to have their sort of role in their state, but people in their state will come up and say, well, you know, the Attorney General or some state says it's illegal or legal. What are we doing here? What's going on? And they have to take action. And so you have, you're going to go state by state by state to do that. 43 of the 50 AGs have to be elected, and the other are sort of accountable to somebody to be elected. So they all have that as part of their role. But they also understand, and this is not like, you know, tobacco for them, which is the biggest issue. That's what put attorneys general on the map in the late 90s, where the view from the attorney general perspective is you smoke, you're going to die, ultimately. And this is something that they see that people want to be able to do, but they're having a hard time sort of relating it to the laws of their state and making sure once that the case came out at the end of September, there was the issue about an employee, that doesn't happen all the time, that people know that that they have a fair shot of actually winning, that the sites say and do what they say they're going to do. And that, you know, kind of crosses all industry. So right now what's happening, unlike in many cases, there's not a multi-state, right? It's just multiple states. So sometimes when a company does something bad, an attorney general goes after that company. They might be in their state or not. They'll go after their company. Sometimes there's a multi-state where a group of states band together. They have an executive committee. They hash it out, and they ultimately come to a resolution. What's interesting about this particular series of events over the last 4 or 5 months, because none of this was going on before September from the Attorney General. I would posit that most attorneys general didn't know what fantasy sports was before September, and a couple things happened, a lot of ads and so forth. But right now it's state after state after state, and it's going to continue down that line. One of the resolutions that I'll talk about that I think should happen is sort of welcoming a multi-state approach in the sense that you get a bunch of attorneys general that are interested, 10, 15 offices, together, and you go, and not necessarily the regulatory scheme that's set up in Massachusetts, but that a regulatory environment comes out of that, including, over 21, no advertising to kids under 21. You can imagine what you'd want to have, or what they'd want to have as part of that. And they want to be able to talk about what they did, because they want to be in front of a television camera saying, this is what I did, this is how I protected the citizens of X state, and now you can enjoy fantasy football, but it's going to be regulated, or fantasy sports, and it's going to be regulated, and we're going to make sure that it's fair for everybody. And then they'll move on to the next issue, student loans or whatever the issue is going to be for attorneys general. But that's how, because right now, we could all quibble as to whether this is skill, gambling, chance. I mean, we all took a chance driving. If you drove here, of not getting hit by a drunk driver. Life is all about chances. There's chances involved, and we could talk about whether it's 99% skill, 1% chance, 40, 60, 50, 50. But at the end of the day, they're going to have to figure out, there's some of both in this, and they're going to have to figure out a scheme to get there. And the attorneys general are going to want to be able to say, we protected our citizens, and now it's fair, and now you can play.
So Paul said we're going to have a no bullshit panel. So I'll ask you a question about the motivations of these attorneys general. There's been a joke that attorney generals are people waiting to run for governor.
National Association of Attorneys General, NAG, National Association of Aspiring Governor. Yeah.
Right. You ran for governor.
I did.
In fact.
Yeah, my wife's happy I lost. Yeah.
How much is what's going on at the attorney general's level a calculation as to what will be most popular, will make them seem most likely to reach the governorship, and how much of it is real, honest to goodness, we are concerned about protection for players? And follow up, if that's part of it, what are the different ways to get there? We can achieve protection and their political ambition.
Yeah, I think that's a fair question. It's the right question. I mean, obviously different people are motivated by different things that get into politics. You like to think they're in it for the right reasons, do the right things, and I think that this is part of it. But like I said earlier, I mean, this is something people want to do. Is it a harm? Does it harm anybody to let somebody put $2 down on a game, or 20 or 200? We could certainly, I think people in this room would have a view on that, which is different than, say, tobacco, which is where they did get interested. But it's they want to get elected, they want to get press, and they want to be seen as being fair, and then protecting and helping their citizens. And this is something that people want to be able to do, and it's difficult for them to discern a difference between this and, say, allowing horse racing in their state, or the lottery is in most of these states as well. So there's already gambling, so there's really not a great moral argument here. But I think ultimately I would, since it's a no BS thing, I would say if I were sitting in the chairs out there, I'd want regulation. I'd want regulation because A, the problem goes away. B, I'd want the attorneys general to collectively make that decision as to what that regulatory scheme and framework will look like, because then the feds would adopt it. It's a very unusual situation where the states would go first and then the federal government. When I was the president of NAG, we did the national mortgage foreclosure settlement at the state level. We did it with all the states. We ended up getting 49. General Pruitt in Oklahoma had a different view, but we had 49 states, and then ultimately Oklahoma came along, and then that became the framework for the federal government. I think you could do the same thing here. So instead of fighting like whack-a-mole each of the 50 states, you could come together and have, and the attorneys general can talk about what a good thing they did, to your point, to get elected. And I think that's sort of ultimately what you want. And the reason why you want regulation also is because I would imagine you all are in this room because you were successful enough to be able to afford a plane ticket or gas to drive here. What you don't want to have happen is the copycats, the people that create FanDuel Part 2 or DraftKings Part 2 in their garage. And actually, I think it was mentioned earlier, one company didn't pay their people because they went out of business. You want to prevent them from entering the market without having sort of all the protections in place for the consumers and their company.
So Jeremy, I was going to turn to the legislative effort. I wanted to comment on what Doug had to say, and then I have some questions for you about legislation.
Sure. I think one of the things that we're seeing with the AGs, and I'm involved in it in a little bit of a way, just because it does affect what we do in the legislatures, is you talk about states, and I know we're going to get to Texas, Illinois, Texas, New York. These attorney generals, in our experience, just don't know anything about fantasy sports. They didn't play fantasy sports. They don't understand how it operates. And that's critical. As you all know, I mean, there is... So someone who's never played it doesn't understand that when we put together a team, I've been doing this for 20 years, that no, I'm not the one on the field playing, but there is some ability to use my skill. Not some, there is a tremendous amount of skill involved. And it's very difficult, or has been difficult, to get through to them that this is a contest of skill. and what it's involved. And I think when you see with Massachusetts, I think that's a great point that she was an athlete. And it may be that her office just has a better understanding how fantasy sports is. So for us, education is going to be important. But I definitely think, at least from our vantage point, or my vantage point, there is definitely a political aspect to it. I think there's been a miscalculation. I don't think Eric Schneiderman ever realized just how many people play and love fantasy sports, including daily fantasy sports. And that's going to be an important point going forward, is the more that these elected officials hear from us, from your customers, how much you love it, it will have an impact, in my opinion at least.
So let's talk about that. Peter, you go to states, you've been leading legislative efforts. When you go on behalf of the FSTA, what are you trying to accomplish when you speak to legislators? How do you educate them, and what are you trying to get out of the process?
Well, just to step back, I mean, just to reiterate what Paul said, we're trying to go to all as many states as we can, 50 states, 40 in session this year, to try to, clarify, have legislation that clarifies it's legal. We believe it's legal right now, based on most states, how they view games of skill, how they view contests, but let's go in there, let's clarify it. And if there's, common sense consumer protection measures, we're going to support those, like we said. A lot of those are the ones that we, as an industry, have already embraced through what we've done at the FSTA before, stuff like segregation of player funds, 18-year-old minimum. So a lot of these things are things that if we want to put them in the law, we're fully supportive. We've always been supportive of them. And there's some other ones that, we're working with them, and there'll be some more issues. But for the most part, the main ones are pretty basic that I think everyone in this room would agree on. And then we're also looking to even the playing field for consumers. I think that's a big thing for the trade association. We want to be supportive of those kinds of measures. As a lot of new wrinkles come up with new technology, new game format, who would ever even heard of the word of scripting like 3 or 4 years ago, right? Things like that are going to happen, and so that's our goal, is to make it so that consumers, players, all are on have the same, even playing field. And then the last thing is, and this is more my role, is to really make sure that we don't get onerous regulations that are unfair or too much for smaller operators, season-long operators, not just daily operators, that everyone is going to be able to continue to do their business the way that they've been doing it successfully for 20 years without major or even any consumer protection issues. We haven't had that as an industry. So that's really kind of my role. And as part of these hearings, I think, what I can bring to it is that, having been in the business for almost 20 years now and played for almost, 30 years, try to educate them on how it works as a game, how it's good for your fandom, how it's good for the leagues, how it's good for the teams, and just how it's a really wholesome industry in terms of how you play. And I think when legislators start to see that, if they haven't played, then they start to grasp how it's different than than sports gambling or craps or tables or other gambling products.
So Jeremy, other than ignorance, which is what we're saying, that they don't understand how the game is played, what are the obstacles to getting legislation passed? Is there opposition? Who are they? What are the difficulties? Why don't we get the bills sailing through?
So the obstacles are, I don't want to put a number on them. There are many, and they're always changing. But one of the obstacles is just the legislative process. We had our bill in Kansas last year. We were this close to getting it passed in May rather than in June. And the speaker had a birthday party to attend, and he just adjourned session right before our bill was going to get caught up. So you have those nuances of how legislatures work. There's other priorities. It's difficult to pass legislation. It's by intention. And that's just at the state level. At Congress, it's like the 4-minute mile to pass anything. But I think that, the obstacles we're facing are opposition not from the casinos. That's an important point. I think that we've gotten to a place with the AGA where they've been at least neutral, if not supportive, of our efforts to get legal certainty. And that's a huge change from last April. MGM has been helpful. They've made comments. So that's a great thing. But, we are still running against people who just don't understand what we do. So we actually have to not only educate legislators about what we do, but we also have to educate potential opponents that we are not, in fact, competition for the video poker in the truck stops in Louisiana. The video poker machines in the truck stops. That's not what our players are using. Or if they're using them anyway. They're not just saying, oh, I'm going to go play DraftKings or FanDuel instead of going down to the truck stop and play my 10 games of video poker. So that's definitely what we're running into. But I think the good news on the legislative front, maybe as compared to some of the AGs, is that we really have found a lot of enthusiasm for fantasy sports and a lot of interest. And it's not so much, I think, that these bills will die because of opposition. To the contrary, I think if these bills don't make it this year, it's simply because, like I said earlier, it's a process.
So let's talk about a real-life evolving situation. We haven't said anything about Texas. We're sitting here in Texas. The conference was moved from Las Vegas to Dallas. Yet yesterday there was an adverse development, maybe expected, but an adverse development in Texas. What happened? And then let's just play it out a little bit. What are the options for doing things differently in Texas? How do we think about the legislative options? How do we take what happened yesterday, again, not entirely unexpected, and move forward with it? Anyone want to start with?
Why don't we let Doug start with you?
Yeah, well, so Ken Paxton yesterday issued an opinion declaring it illegal. And I want to take a step back for a second. What these two are doing has been really is important, incredibly hard work, and I think they need to continue to work at the 50-state level on the legislative side and making sure good laws and rules are passed so that people can operate in the online world. At the same time, though, there has to be another track, which is the legal side. And Mark does a wonderful job with that as well. And right now, it's just teed up. So what's different about Texas is, first of all, you guys look incredibly, have this great foresight to know that, the day the conference starts, they're going to issue an opinion. That's the kind of thing that takes skill. But the fact of the matter is that he came out with an opinion yesterday. There's a couple of things that are notable to me on that. One, he's the first Republican, I think, because you asked, but it's real. This is politics, right? So all the states we've talked about so far are run by, Madigan in Illinois is a Democrat, Schneiderman in New York is a Democrat, Frosch in Maryland's a Democrat. Pick the state, it's been Democrats. This is the first Republican, and so. There's within NAG, there's RAGA and DAGA, Republican Attorney Generals and Democratic Attorney General Association. So this will start, now one of them's done it, this will start a movement where others can sort of follow suit. So that's what I thought was significant about Texas. But the other thing, I'm going to reiterate something that was said earlier, which is a very important point. Just because, and my mother thought I had the most important job in the history of the world, I get that. But just because an Attorney General issues his or her opinion doesn't make it law. It's exactly what it is. It's an opinion. So now it's a little higher than anybody here's opinion, or my opinion at this point in my life. And so, but it still it's below a legislative law or a court ruling. So when I said earlier, I think I'll come back to it now. It seems like the industry is getting pounded state by state by state, yesterday being the new one, on these attorneys general opinion. On the other hand, the moment is now, because there's leverage now before a court rules. Even New York hasn't ruled. They just issued a stay and said, we'll rule later. While in this window between attorneys general coming out with their opinions and any court actually ruling, this is when you need to get sort of the regulatory framework set up where it's sort of best practices. And instead of looking at one state versus the other, in this room and the board itself should come up, the FSTA board can come up with what they think are things, and you said we mostly agree with a lot of them, come up with what it should look like and say, this is the model we think will work for everybody. It protects consumers, protects the integrity of the industry, and allows people to enjoy something they frankly enjoy doing, which is playing fantasy sports. It helps the sports industry wins that way as well, because more people watch sports because they have players involved in the game. So right now, even though it looks like you just got pounded in Texas also, it's an opportunity. I think Texas legislature, you guys would know this, meets like every 700 years or something, right? They meet like every other year.
Yeah, I was just going to throw it to Jeremy and say, is that what we're doing? Do we have the bill that we push for? And can we run into Texas tomorrow and get it passed?
We could run to Austin tomorrow. There won't be anybody there to run to, unfortunately. The legislature is out of session until next year. It is some matter of frustration that, of course, we get an opinion when there is no legislative session. That was also true of Nevada, which was another actually Republican state, Republican AG. So no, that is not an option right now, but it means that we have 10 months or 11 months to build support among Texas, players and others, and reaching out to somebody cut me off there, reaching out to their state representatives and their state senators and saying, I want you to pass legislation that confirms that this is legal in our state.
So Peter, where are we optimistic? Doug's used the word pounded, but we do think this is an opportunity. You put together bills. Where are we optimistic?
Look, I think the message to the industry is, I know there's a lot of legal talk here, but I think that when you look around to all the state legislators, you find people who are supportive of our industry who say this just isn't really right here. The people want to play fantasy sports. Let's figure out a way to do it. Yes, there's a couple of consumer protection measures that we have concerns on, but I think when people sit down with us, we can hash it out. And so I think what's going to happen here in the industry is we're going to get a movement across the country from people who are advocating for us. We're going to pass some bills, and I think that's going to turn the tide where suddenly, suddenly people look at us at a different light, and they feel like, oh, we've digested the issues. These consumer protection measures. We're addressing that in the states. That's the model that we're going to go after, and I think that that's going to suddenly catch fire and roll across the country, like we said. So I'm actually optimistic. I mean, when we're in these state legislatures, like the New York hearing, I think to me was probably the best example. It was 3 hours. We got tons of questions, tons of insight. But at the end of that hearing, despite all of the hostile questions at times, they came out and said, you know what? We want to keep this activity to continue in New York. And I thought, wow, that's really shows what we can do here when we get in there and talk to people. And so I'm pretty optimistic. We've got bills in a ton of states right now, 10 plus, and I'm optimistic that we'll be able to pass a bunch, if not this year, put us in really good position the year after.
So let me just say a word about Massachusetts, because we're talking about positive models. So Peter went up to Massachusetts and testified at their open hearing. On Friday, Massachusetts will be receiving comments from the proposed regulations that came out. The comment deadline is Friday, so various operators and the FSTA will be likely putting in comments as to what those regulations should look like. And then the regulations will be issued, and there'll be a certain period of time for everybody to come into compliance with them for Massachusetts players. But doesn't that provide a model for the rest of the states? Doesn't it provide a model to say, look, there's no need to make fantasy sports illegal when the main concerns are consumer protection concerns, and look, here's a way to handle it, here are ways to build regulations that level the playing field. Isn't that a solution?
We really like their approach. They really dove into the details, got a lot of education, talked to a lot of the companies here, a lot of the FSTA, and came back with a lot of regulations that, you could tell were educated. They didn't get it all right, and we're going to give them feedback, and they're listening. But I think that if other states are going to look at that, and I think that's why it's really important for everyone in this room to give us on the board, and me in particular, your feedback. If there's something in those regulations that you don't like, let me know, because they will probably be the model for the rest of the states. Other states will look at those. Now, luckily, almost all of the things that are on there, like I said before, are things that we internally have advocated for years, so that's not a big deal. It's not we don't have a lot of issue, but there are some nuances. So definitely give us feedback. We're trying to represent all of you. A lot of people have brought me some great information and points into the board that we didn't think of, and then we made that as part of our case and part of our testimony. But I think that goes for other states. The early states are going to get a lot of attention. They're going to be copied by the other ones. So let's make sure we get it right. Yep.
Just to add to that, I think one of the strategies you could have, I think there's a lot more room for optimism, I think, on the legislative side, because the legislator's job is to represent the people that they represent, their constituents, and people want to be able to play online sports. So I think there's room for compromise, and if the decision ultimately is, let's put our focus on Massachusetts because it's sort of further down the line, and there's a receptive attorney general to get a best practices regulatory framework passed, that actually could happen, and these guys will do a great job making sure that happens, and then you could export that to other states. They're not really they're kind of looking, but you have to you got to push that on the other states. Say, look, we did this in Massachusetts, it works. This is almost a way out for the attorneys general, because they're at this point they could use a way out, because they've now stopped people that they have to vote for them to do something they want to do. The place I'm less optimistic, though I could be wrong, is in the courts. And so, you have to, and Mark's team is doing a great job of this, you have to keep fighting in the courts, but sort of right now is not the time to have a scorched earth policy view on litigation. You need to try and figure out where the common ground is, how can we work together before you get to the courts and start getting bad court rulings. So, I think Massachusetts is a great place to do it, and you might want to think about getting other states involved earlier, because the Attorney General opinions, what they're supposed to be, is a foreshadowing of what a court would do, what they view, and their office does, a foreshadowing of what a court would do if they were confronted with this situation, and so far the opinions haven't really gone our way yet.
So let's do this. A lot of people came up to me earlier and said they want to make sure there's time for questions, because people have a lot of questions. Think of your questions now. I'm going to ask one more question of the panelists, and then we'll open it up and do 10 minutes of questions, and then we'll break and have Mark Cuban. So final question for you guys from me. There's a question about whether these activities are all against daily or whether they're against season long. The Texas Attorney General opinion came out yesterday. It did not really distinguish between the two. It said if you run any type of contest where there's a commission or any kind of payment to the operator, in the AG's view, it's illegal. If you run a commission or product where there's no money other than just an administrative fee, it's not illegal. What's happening at the legislative level? Is there a distinction being made between daily and season long? Is it meaningful, or is everybody really in this boat together?
No, there's no distinction being made, nor should there be for paid fantasy contests. We need to have clarity that fantasy sports contests are not illegal under existing law, that they are legal, I should say. That we need to confirm that. If you look at Florida, that's the oldest AG opinion from 1991. There was no daily fantasy sports then. There was no internet. Well, there was, but not really a widespread use of the internet then. That was about social season-long fantasy sports, and it was just opined that that was illegal under Florida law. So we are all in the same boat here in terms of that we need to get legal clarity that fantasy sports contests that meet certain criteria, the criteria basically set forth under the federal statute, under the UEJA statute, that those are legal. And then we have consumer protection obligations that really are focused on just a certain segment of the operators.
You know, in meeting with legislators, it's been very difficult for them to understand fantasy sports in general, you know, especially if they don't play daily fantasy sports, the nuances. And so I think that a lot of people went into this approach thinking that, you know, if you had an existing company that you ran a full season or whatever contest, playoff contest, shorter duration for years, that you'd be insulated. And that just hasn't been the case. And we've seen that in Illinois, we've seen that here, and that's unfortunate, but that's just reality. And so I think, you know, what we're trying to do going forward, with the laws, the bills we're proposing, the laws we hopefully will get, is to try to ensure that the regulations are not so onerous, they don't impact the businesses that have been out there for a long time, the high stakes leagues, the $30 entry leagues, those kinds of leagues. We don't want to make it so prohibitive that those can't play anymore. So we're fighting hard. You'll see, you know, some fees involved in these bills. I would like to remind everyone that it's a long process. What you see initially is not what ends up behind the scenes. We're working really hard to make sure that those things are not onerous. But at the same time, when you guys, you know, look at them, give me feedback. What don't you like? What isn't going to work for you operating your business? And we'll be out there trying to advocate for that as much as possible.
So one other preview. Later this afternoon or later this morning, we're going to hear from Rob Pythian about what people can do on their own to influence these efforts at the legislative level with attorney generals, with bills. So we'll hear about that. We're not going to talk about that on the panel. Doug, do you have something quick to say before I open it up?
Well, I just wanted to reiterate, I think, Jeremy's point, and it was exactly right. You do not, and right now a lot of the media and a lot of the conversation is trying to distinguish the two. I think you have to look at it one thing, because you don't want to start going down that path. What about weekly? What about monthly? What about bi-weekly? I mean, it's either you want to have regulation where it's legal and under regulatory framework and go forward from there.
Okay, so we have time for a couple questions. I'm going to do the disclaimer for all the lawyers on the panel, because there are 3 lawyers here. Nothing you're hearing is legal advice to you, although I'm sure Doug and others are generally available to give you legal advice in the hallways afterward. So with that, we've got about 7 minutes for questions.
I'll even discount my fee.
And 6-minute intervals they charge us.
Go ahead.
What exactly happened in Maryland where a law was passed, you know, allowing fantasy sports, and then we have to examine it and push it back again? Why did that take place in Maryland when Peter's worked a few years back?
Right, I'm just going to repeat the question so everybody can hear it in the room. Why are things happening in Maryland? There was a law passed that authorized and legalized fantasy while Doug was Attorney General in 2012. Why is it being questioned or challenged in any way?
And it goes to the last question we talked about, the daily online. So when, in 2012, when it was carved out, we were, well, then I was sort of the other side, not really. But obviously it wasn't, because we decided it was constitutional. So they passed a law that carved out fantasy in 2012, every law that gets passed, the Attorney General of every state has to opine whether or not it's constitutional. The rules in Maryland say if you're going to expand gaming, it has to be voted on by the population in the next ballot. And I ruled that it wasn't, this was not gaming, this was not gambling, because at the time, frankly, there was no daily online, which has really changed the conversation a little bit within Maryland. So everyone would have been honky-dory and fine. We live in a world where fantasy is completely legal in Maryland. And by the way, we still do, because we just have had an opinion, and even that opinion was a little murky to say the least. And so you're in a situation where 2 years later, 3 years later, the president of the state senate asks for an opinion. So if any elected official, this happens in all states, asks for the attorney general to give an opinion on something, they do it. No, a regular citizen can't, but a legislator can. So Mike Miller was the president of the Senate. Miller asked for it, didn't he, Jeremy?
Yep.
Yeah. Miller asked for, Mike Miller, the president of the Senate, said, I need clarification. I don't think this is what was intended, but to carve out what I'm seeing on television every day and so forth. Can you tell me whether or not it should go to the voters? And basically, the Attorney General of Maryland, the now Attorney General, said, you know, I don't know. Let's let the legislature decide, and we'll revisit it afterwards. So that's what happened in Maryland. The idea is that it was a different world in 2012 than it is now. Let's have a refresher opinion on the subject.
Just one clarification. There was evidence in the 2012 record that there was daily. Obviously, we were all here at the conferences. There was plenty of daily, but there was only one reference to it in the legislative history. So there's the AG suggesting that maybe if they'd understood daily was involved, it might have been an expansion of commercial gaming. But you know, I think most of us who looked at the opinion think it's not right, that it wasn't an expansion of commercial gaming. What it was is a bill that said this is not gaming, and that didn't need to go to the legislature, didn't need to go to the referendum process.
You know, on the politics side, it's just kind of frustrating because I think there's a lot of revisionist history because, I mean, in 2012, there were daily companies. There were $100,000 prizes you could win in season-long leagues. We were a vibrant industry. This wasn't a bill just to legalize a bunch of guys playing, you know, in their, you know, offline, you know, for $10. I mean, we made the case then. And so that's what's been frustrating. And so I think that, you know, in Maryland, we're definitely, from the FSTA perspective, going to fight really hard to make sure that that law is what it's intended to be.
And not only that, just to flip the question on its side, because there are also 4 or 5 states where it's actually illegal to have online, and the companies don't operate there. Once you get a regulatory scheme, say it's Massachusetts or elsewhere, I would submit you should go back to those states and try and get new legislation in those states so that you can operate in Iowa, Montana, Louisiana, whatever the states are. Arizona.
I got a question down here in the front row.
Congress passed the UIGA, they expressly referred to the states on what is illegal gambling. But a lot's changed since then. Is it a viable solution that Congress would act to preempt the states on this issue?
So repeating the question is, UIGA, when it was passed, it did not take away the state's right to decide what's illegal or legal gambling. It let states define unlawful gambling. Is there a solution now where we could get a federal bill that would preempt all the states and would just say that this is lawful and therefore we wouldn't be doing it on a state-by-state basis? Jeremy, federal preemption?
The short answer is no. I mean, it would be, Congress just does not pass laws. They're not going to preempt states on what is and what is not gambling. They have only done that once, and that was on sports betting. But I think it's very clear that Congress is not a place where you go for solutions these days. That's the state legislatures. I know that we didn't learn that in school, but that is the reality. I mean, we can talk about it, but the reality is that this will be answered or addressed at the state level.
And they may ultimately do it once the states come to a resolution about what they think works best, right? Because, I mean, to echo that, I mean, they can't decide whether today's Wednesday or not. I mean, they can't agree on anything right now. And so, and particularly watching the states grapple with this is giving them an opportunity, better opportunity just to step back, see what happens with the laboratories of democracy, those are the states, and then ultimately they may actually embrace a federal law that mirrors what the states come up with.
And I'll say the FSTA does have lobbyists in Washington. We're definitely proactively watching everything there, but our expectation is that in the near future, this is not going to be an issue that's addressed at the federal level.
Okay, we got time for one more question. Right here.
Are we trying to put a line in the sand for the fees that are associated on a state-by-state level for like some of the operators that might be on the small business side of the equation?
So I don't know if everybody heard that, I'll just repeat it. Are we trying to do something to solve for the fees question, that if each state puts in fees to get registered and to do business, it might really harm the small operators? Are we trying to solve for that?
The short answer is yes. Let me just explain fees very quickly and just dispel maybe at least one myth. We have this regulatory framework that's starting to be roll out in state legislatures with these bills. The bills all look very similar. And when you ask someone to actually oversee the fulfillment of those consumer protection obligations, that means the state has to hire someone, or 2 people, or 3 people, depending on the state. And states like to be paid for that, or at least to have someone cover those costs. They don't do this as a pro bono situation. So that means that we need to make sure that there is enough revenue coming in that can pay for those individuals to oversee what these consumer protection obligations are. So we need to at least have fees that generate enough revenue to cover the cost. And in some states, bigger states, the numbers they've thrown out initially have been significant. The myth that I want to dispel is that this is somehow a move by FanDuel or DraftKings to create barriers to entry for others. I mean, that is the last thing we're thinking about right now. What everyone is thinking about is how to pass these laws. So no one is trying to use this for competitive advantage. We are using this so that we can survive and thrive in the years ahead. We've already worked on an amendment that I think will start getting rolled out that will address the fee situation, that will put in a percentage a floor essentially that bases it on a percentage of a difference between entry fees and prizes paid out at the state level. So smaller operators would just pay us like a 5% of what might be their net revenue. That's something we're rolling out. We're speaking to states and we're making the argument that the lower you make the fee, the more people who will actually register and be able to operate in your state. So this is not a play by states to actually, screw the little guy. What it is just an attempt to address an issue, a budget issue. And we don't want to get held up in appropriations committees, nor do we want to have legislators say, I'm not passing this because this is going to tax fantasy sports. So it's something we're dealing with. Yes, please.
5% of net revenue is about 50% of margin at a company that makes 10%. That's not a small amount, man.
That's per state, and that would be 5% of. We can talk about what the specifics are outside, but we're
It's a low margin business. If you're taking 5% of revenue at a company that's earning 10%, that's 50%.
no. It would be 5% of your margin, of your profits. Yes. Yes. So yeah, no, that's okay. That's okay. It's important. Math. I like most lawyers. I stopped taking math in 11th grade, so I should never even get on this kind of subjects.
Right. I just want to reiterate that on the fees issue, it's definitely not the policy of the FSTA to try to use, have barriers to entry to support, a couple companies with sizable companies. FanDuel, DraftKings, the major media companies, they've all been very supportive that these fees, not be high, not be a barrier to entry. And that's a misconception that's out there. We want to clear that up. We're trying to make this to work as much for everyone as possible. And if that's a really good point, and if anybody else has other issues like that, I'd love to hear them.
So I hope you all join me for Peter and Jeremy for all their hard work that they've been doing on lobbying, and for Doug and the whole panel for sharing all their insights today. Thank you very much. Hope you join me.
Thanks.